the panel delivered a verdict, and by a 3-2 majority decision with Her Ladyship Justice Henrietta Mensah Bonsu and His Lordship Justice Ernest Gewu dissenting, delivered a 3-2 majority decision dismissing the application for the suspension of the Chief Justice by President Mahama. When I caught up with the former Attorney General Godfred Dame, I asked him how damaging was the fact that he failed to point to any provision in Article 146 that spells out clearly the timeline within which the President must notify a Chief Justice once he receives a petition asking for the sack of the Chief Justice. Listen to what he had to say.
Clearly, we cannot lose sight of the fact that whatever has happened, the benefit of it accrues to him. And it is incongruous in the constitutional history of this country. We've never seen any development like that before. Whenever there's a dispute as to the status of the Chief Justice in this country, start from 1980 for an Attorney General, start from 1983, 94, Aban.
Your main argument, your final was the fact that the President's failure to notify the Chief Justice from the outset constitutes an egregious constitutional violation. But one of the panel members pressed you. He wanted you to point the panel to the clause in Article 146 that clearly stipulates the timeline.
The reasons for the decision have not been known. Of course, clearly, I mean, the spirit of Article 146 we're talking about. In the first place, it is important to indicate that nowhere in Article 146 will you find the requirement for prima facie determination made for a Chief Justice. But the Supreme Court itself imported that into Article 146.
The plaintiff in this matter, Vincent, the Member of Parliament for Old Tafo, I asked him if he's disappointed with the court's ruling.
I don't think this is the end of the road, but let's just get the reasoning first. When we get the reasoning, of course, the 3-2 ruling suggests that the Supreme Court itself sees some reasoning in the arguments that we made.
What do you make of the fact that your counsel couldn't point out to the provision that clearly states timeline within which the Chief Justice has to be notified upon receipt of the petition by the President? How damaging was that to your case?
Well, I was even surprised that it even came up, because Tufo versus Attorney General clearly tells you that in reading the Constitution you have to do so by the letter and the spirit. If anybody tells you that because something has not been clearly stated in the Constitution, and for that matter, it has no potency, I am telling you that that is not the case.
Deputy Attorney General Justice Shrem Sai, on his part, hailed the judgment of the Supreme Court. He says the former Attorney General was basing his argument mainly on publications and not necessarily the law.
So you realize that the question was consistently put. What exactly are you alleging? What is the right that you are alleging? And to pile up a series of newspaper publications claiming that because newspapers are published that the president is attacking the judiciary, that is enough for the president to stop the process, or the process is unconstitutional because some newspapers are published. That cannot be a very strong legal basis. And you saw the attachments of newspaper publications, many of them. I don't think that a publication is a legal right or determines the legal right for anyone.